Hi, everybody. Welcome to another episode of Ask Me Anything. My name's Yaasha Sabba, and I'm with Sky Unlimited Law. We're going to answer your estate planning questions right here in beautiful Florence. The first question that we have for today was sent in a good second ago, and now we finally have time to answer it. This person says that they have two nieces. Can non-American citizens be on my trust and be entitled to getting any of my inheritance? I want to add my two nieces to my trust, but my concern is that I'm in California and my nieces live in Paris, and they are in the process of getting green cards. Thank you. This is actually a very straightforward question. It's not necessarily about trust. It's about any estate plan for that matter. If you have beneficiaries that are in a foreign country, meaning they are not U.S. citizens, they're not U.S. residents, then yes, there can be a tax implication that happens for those beneficiaries. So if you have a trust or if you have a will and they're inheriting through probate any of your assets, there is going to be a withholding tax. The rule of thumb is that the withholding tax is going to be about 30%. What does that mean? That means if you say, I want to give money to my two nieces, let's say you want to give $10,000 to each of your two nieces through your trust should something happen to you. Your trustee or whoever is in charge of your estate is going to have to withhold 30% of that money, give it to the IRS so that your nieces in Paris can file a tax return with the IRS saying, give us a tax refund. So the reason we do this is because the government doesn't want money leaving our economy. And the government also doesn't have jurisdiction over your nieces to pay their taxes. Now, generally speaking, as you might be aware, there are no taxes for inheritance. So why do we have taxes for inheritance to foreign beneficiaries? Again, it's about money leaving our economy, and they don't want that to happen. So usually it's not a 30% tax that's owed, but because this is a withholding tax, it's kind of an opt-out, opt-in situation where your nieces need to do their job and file a tax return with the IRS. Even if they're not citizens of this country, the fact that they are receiving money from an American citizen in this country through the inheritance, they do have the ability to file that tax return. Now, depending on what country they're from, the United States might have a tax treaty that says, okay, we don't withhold 30%, we only withhold 12%, 15%, who knows? The point being is when they file that tax return, that's them saying to the IRS, you owe us money because we weren't supposed to lose 30% of our inheritance. We were only supposed to lose 5%, 12%, whichever the tax rate is between the two governments that have that tax treaty with the United States. So here, in this case, we're talking about France. France definitely does not have a 30% withholding, but it is the trustee's job to withhold that money. It is your niece's job to file the tax return to get that money back. Chances are they're not going to file that tax return and the government receives more money. Do you see how this kind of is a little twisted and it works this way? So if you care about having beneficiaries that are not citizens, you receive an inheritance from your estate, there is going to be a withholding tax of 30%, and it will be up to your beneficiaries to file that tax return to get that money back. Now, on the alternative, for you in particular, because you're setting up a trust, if your nieces are getting their green cards where they plan on maybe building a residence here in the United States or potentially becoming citizens, then instead of making an outright distribution where if something happens to you, the money just goes to them automatically, or not automatically, but without being held in trust, you can hold the money in trust for them, in which case, by the time they do receive their green card or they do become U.S. citizens, there won't be a withholding tax problem anymore. That withholding tax only occurs when you are making a distribution of money into their hands, okay? The moment you do that, the trustee has to withhold 30%, give them the rest. But if you hold the money in the trust for them during their lifetimes, the money can be used on their behalf for anything they need, buying plane tickets, buying a house here in the United States so that they can come and visit if they need a place to stay, That won't necessarily, you still have withholding tax implications there, but by the time they get their green card, instead of all the money being taxed, it can stay in the trust for them, and it only gets taxed when it's used for them, not as long as it's held in the trust. And it could be held in the trust and continue to grow. It's when a distribution from the trust is made, will that tax be called on them. So if you hold the money in trust for them during their lifetimes, and that money can be invested, it can grow, the trust will pay its own income taxes and stuff like that, then by the time that they become citizens, they won't have that withholding tax issue anymore, and then the money can be distributed to them tax-free. Do you see how it's nice and flexible when you do this with a trust? Whereas with other options, you could do this in a will. If you set up a will, you say, take this money, hold it in trust for these beneficiaries, and then that way there's no withholding tax. The money doesn't go immediately into their hands, and once again, it's held in trust for their lifetime. So that is one option there. Another caveat is be also careful. We were talking about the beneficiaries being foreigners, non-US citizens, non-residents. Be careful about your trustees. Your trustees need to be US citizens. If your trustees are not US citizens or US residents, then all of a sudden your trust can be converted into a foreign trust. What does this mean? No tax implications where all of a sudden the trust pays more taxes, nothing like that. It just means there's a lot more disclosure to the IRS. The IRS, again, it's about jurisdiction and control of the United States government. If there's a foreign trustee, like if one of your nieces are the trustees and they're not citizens, they're not residents, and all of a sudden, all of the money inside of your trust is now controlled by a foreigner, and the United States government has no jurisdiction over them. So because of this, the government wants to have a little bit more control over the trust itself. They require that you disclose to them 100% of all the assets and their values every single year. So if you ever have a foreign person in charge of your estate or your trust, there are going to be a little bit increased costs on the administration. Because of this excess disclosure, you're going to need a CPA, you're going to need valuation firms. It almost can double the costs of managing the trust or your estate. So that's just something to keep in mind when you have a foreigner in control and in charge running things. And then, as we answered in your question here, when you have foreign beneficiaries, what are the implications with that? So you can still give to your nieces. There's no restrictions on that. There's just some tax withholding requirements. And if you don't want to pay those tax withholding requirements, you do have options on how you can structure your estate plan or your trust where the money can be held during their lifetimes, be used while they're here in the United States on their behalf, but it won't be distributed to them until they either become a citizen or at least a permanent resident where it's not as strict, these withholding requirements, all right? All right, a nice, quick, and easy question. That's it for today. Let me know if you have any other questions. Email us at info@skyunlimited.law, or just send me a message on Messenger, and we will answer them during these Ask Me Anythings. Thanks, everybody. Take care.